So, what's going to happen at an MSC, at a mandatory settlement conference? So, I will say, backing up just a little bit, one side or the other has filed a DOR for an MSC. Basically said discovery has been completed on this issue. I've made these good faith efforts. It's supposed to be outlined in the DOR, the good faith efforts to resolve the dispute. I've written to the opposing party several times. I've called, I've emailed, whatever it may be. But I'm ready to set this issue for trial. I will say, for the opposing side, if you don't want it to go to trial, so you're an injured worker, you don't have an attorney, the insurance company files a DOR, they want to take the case to trial, but you're not ready to do so, you need to file an objection, and that needs to be filed timely. So you need to do it in writing, serve it on the board, serve it on opposing parties, and let the judge know why discovery should not be closed, what further steps need to be taken. So let's move forward now to the MSC. Let's say a DOR was filed and no objection was filed to it. So now you're at the MSC. Generally, you're going to go before the judge. It's still going to be telephonic these days, so it will be on the AT&T conference line. The judge will generally call each of the matters and find out which ones have joint resolutions and which ones don't. So if there's a joint resolution, may note those on the minute of hearing and dismiss the parties. And we'll probably have the parties hang on the line so that he or she can circle back and go over the ones that don't have an agreement. So the judge circles back, calls your case. You're an injured worker without an attorney. You're on the line, on the AT&T conference line, and the defense attorney, most of the time, is going to be on the line. It probably won't be an adjuster, so it will be you, unrepresented, against an attorney. The judge is then going to ask both sides. It's up to the judge who he or she calls first. I would call, as a judge, whoever filed the DOR first, but it's up to your judge. Calls each party, finds out what the dispute is. If there's still a dispute, oftentimes what the judge will do is send the parties off the AT&T conference line, have them talk offline. So injured worker may call the defense attorney, vice versa. You can talk for 10 or 15 minutes, see if you can work out the dispute. Maybe the defense attorney calls the adjuster for settlement authority, whatever the dispute may be. The judge will often give you a time to call back in. So let's say the judge tells you to call back at 9:30. You and the defense attorney will call back at 9:30, and again, the judge will, fingers crossed, ask if there is a joint resolution. So maybe you and the defense attorney had a chance to work out the dispute. Judge will be tickled to death. If not, then the judge has to decide what to do next. He or she will listen to both arguments, and the judge may take the MSC off calendar. So if you had filed an objection or the other side had filed an objection, the judge may note that objection, may note the good cause to go off calendar, likely for further discovery, and the judge may take it off calendar. He or she may do it over the objection of the opposing party, or may do it with the agreement of the opposing party, but that's one option. It can be taken off calendar. Another option, the judge may continue the MSC either in the hopes of a resolution of the dispute before the next MSC, or the judge may continue the MSC and order the parties to file a pretrial conference statement. So if you're going to set the case for trial, you're going to file the pretrial conference statement. Both parties have to list all of the stipulations, all of the issues, and all of the exhibits. You're now in the big leagues, so if you're an unrepresented injured worker, you're now setting a case for trial. You need to be prepared to do that. I've done other videos on this channel on the various sections of the pretrial conference statement. Another option is that the judge may have the parties fill out the pretrial conference statement during that hearing. So let's say it's 9:30. The judge may tell the two of you, fill out the pretrial conference statement and file it, or the judge may even have you email it to him or her by 11:30 and then call back in. At that point, the case may get set for trial. All of this is within the discretion of the judge. But this is, in short, what's going to happen at the MSC. The main difference with an MSC and a status conference is that at an MSC, the judge can close discovery. That does not generally happen at a status conference. That would be fairly rare. But at an MSC, One party has said, we've completed discovery. We've got the PTP report. We have the panel QME report. We've discussed settlement. We're done with discovery. Let's just be done with this case. The judge has the power to close discovery at that point, and it would be noted on the minutes of hearing that discovery was closed. Basically, what that means for an injured worker, you can keep treating, you can keep going to your doctor, and the doctor reports, your primary treating physician reports, are generally still going to be admissible even after the MSC, but basically everything else will not be admissible, anything that's obtained after that. So let's say you have an MSC, the judge closes discovery, you're set for trial in 3 months, 4 months, because the calendar is backed up, and you think, I'm going to write to that QME and get a supplemental report. Generally, it will not be admissible because the judge has closed discovery. Same type of thing if then you write to the defense attorney and say, you know what, I heard that there were statements and now I want to get those statements, or now we need to take depositions. Not generally going to take place because the judge has closed discovery. So that's the main thing at an MSC, is that the judge may close discovery and set the case for trial. So if you're going to an MSC, you need to be prepared if a DOR was filed by the opposing side, the insurance company, and you don't want discovery closed, you should file an objection to that DOR. The next thing you need to be aware of is that the judge may close discovery at that MSC during the AT&T conference line time. And then generally the main options at the MSC are going to be either to go off calendar, to continue the matter to another MSC, or to close discovery, set the case for trial, and then the case will be set on notice. So those are the main things that will happen at an MSC. If you have any other questions regarding that, drop us a comment down below. And if you like this video, hit the like button.